And thank all of you. Can you hear me, first of all, if you want to? I mean, can you hear me in the back? Okay, good. I'm thrilled to be here, and I will confess immediately that I don't know what to expect from Irish law students entirely, okay? So I will simply tell you what I'm willing to have, and what you want to do with that is up to you. I'm more than willing to have questions. In fact, I'll leave time, I think, at the end for questions if you happen to have any, but if you have one while I'm speaking, just raise your hand. I'm told not to expect that, that you're oriented toward a lecture, and that's fine. I'm a lawyer, I can talk. But you are more than welcome if you have questions to pipe up, or if you want to tell me where I've gone wrong, that's more than acceptable as well. Give me an idea about what year in your legal education you're in. Second, all of you? Okay, all right, terrific. So you've been introduced to the concept of law and society, I think, already, and I'll perhaps reintroduce you to it as we go. But what I want to start with today, and what will be a series of 3 opportunities to engage you, is the idea of looking both before and then beyond law and society, and specifically discussing what you might describe as interdisciplinarity, for, if you wanted an academic sounding term. But the project that I'm going to set out today and for the following 2 weeks is to look at the intersections of law with the social sciences generally and with the humanities generally. And this will be an overview necessarily, but I want to justify the project as we go. So today I'm going to simply try to introduce to you why I think it's important to consider law in the context of the social sciences and the humanities, to begin to think about the ways in which the social sciences intersect with the study and the practice, for that matter, of law, and then the humanities intersect, complement, and supplement the study of law and its practice later. So why do this? Why undertake this project at all? Why consider law in the context of the social sciences and the humanities? Well, I think most obviously because interdisciplinary study is important today to every lawyer and every law student. One doesn't go to law school today without being introduced to interdisciplinary study. And 100 years ago, that would not have been true, or 125 years ago. Certainly that would not have been true, but it is very much true today in any of the English-speaking countries. And that interdisciplinary crossover helps us a great deal in understanding what it is that law should do and can do socially. Other fields really do help us understand human behavior. And thus they help us to understand really, again, what the law must do, should do, can do, as well as what it probably cannot do. The mind sciences, which are sort of themselves a blend between the natural and the social sciences, are probably the newest entrant into the interdisciplinary realm in which we study law. And they really do, or at least hold the promise of telling us when and how, for example, the juvenile brain develops, and thus what we can expect and not expect from children or young adults. The legal rules then must acknowledge, we hope, the factual reality of neurochemistry or neuroscience if these legal rules are to be followed and respected. Cognitive psychology, to pick a related area of social science, tells us the importance of things like primacy and recency in the way our brains work and the workings of our cognitive biases, so that we then as lawyers can better tailor our cases someday to a jury's human qualities. These are just two quick examples of, practically speaking, the importance of the social sciences in understanding, studying, and then eventually practicing law. History, to dip into what's usually considered one of the humanities. History helps us understand what worked and failed in the past. And an accurate historical understanding ought help shape legal rules today if legislators, judges value efficacy at all. So, you know, these interdisciplinary intersections really are important, but considering law in the context of other disciplines in the social sciences and humanities, I think also is important for more than these sort of instrumental reasons that I've suggested. It's not, in other words, it's not just that law plus, you know, law and economics, law and psychology, law and literature, whatever it may be. It's not just that the law plus idea helps us to understand better how the law should address human problems. It's more than that. Considering the context of the social sciences and the humanities should allow us to understand better the study of law itself, to understand ourselves and our lives as law students and lawyers. Now, try to develop that just a little bit. Admit with me, if you will, just a little bit of history. Before the early 1900s, in Ireland, in the US, in the UK, wherever, in the English-speaking world at least, before the early 1900s, had you asked judges, law professors, law students, lawyers, had you asked them, where in the sort of tree of academic learning does law belong, they would have assumed that law belonged to the humanities. They would have talked to you before 1900 and all the way back, you know, to Aristotle and the earliest thinkers about law. They would have talked to you about moral philosophy, about political philosophy perhaps, but certainly philosophy. They would have talked to you about rhetoric if you'd asked, where does the study of law belong? History would have been something they would consider. The classics, mastering Latin and Greek. These would have been the constituents of the study of law. At least people would have assumed that before about 1900, as I say. And then along comes this guy, Christopher Columbus Langdell. And he's appointed the dean of Harvard Law School back in 1870. And already before then, he had staked out the notion that law itself ought to be considered a science. And he develops what he's famous for is, at least in the States, what we call the case method, that now universally is used in US law schools. You get a case book for your property class or your torts class. There are digested cases in there, and you read judicial opinions, and you tease out what the rulings are and what the common threads are, and you learn through studying cases, judicial decisions. You learn about what the law is in a particular area of the law. That's, at least in the States, universally the system of teaching law students, especially in the first year. Is that similar here entirely? Or no, are you reading judicial opinions early in law school and sort of learning how judges engage in exposition of law in that way? All right. So that's what, Langdell really develops that. That's his big idea, if you will. And it's a form of new positivism, really. It's a sense that law is delivered positively through the writings of judges. He didn't focus so much on legislators, but law is delivered positively. It's not to be found in the scheme of nature or the scheme of things. But the positivism of Langdell was one in which one could read judicial opinion scientifically, as he understood that term, and develop the schema of the whole body of law in that way, and engage in predictive analysis of how the next case ought to come out. I think, though, in focusing on the case method, which undeniably was a considerable contribution, I think that his greatest effect on the study of law and what we understand to be the law school experience has been shifting away from that implicit, that tacit sense that law belongs to the humanities, and shifting us just as implicitly into an assumption that law really belongs to the social sciences instead. Langdell himself really did seek to bring a scientific approach to law. Back in 1886, he wrote that law is a science, quote unquote. Law is a science. And he believed that the available materials for that scientific study, reported cases and statutes, allowed law students and lawyers to predict the outcomes of cases in the same way that a scientist at a bench lab might predict the outcome of an experiment. Langdell went further. And here I'm quoting him again. This was from an address he gave 4 years before he was named the Dean of Harvard Law School. If law be not a science, a university will best consult its own dignity in declining to teach it. If it be not a science, it is a species of handicraft, and may best be learned by serving an apprenticeship to one who practices. So, as early as 1866, this remarkably dismissive notion of anything other than a scientific approach, as he defined it, to the study of law. If you're not going to teach it as a science, he says, as a university, you shouldn't teach it at all. Let people go, read law under a lawyer, study in chambers or in a law office with somebody and learn to practice that way. Only if it's a science does law belong in the university curriculum. That's Langdell's view. And to a remarkable extent, this man succeeded in bending the way that law students, teachers of law, judges, lawyers, the entire legal profession thinks about the study of law, thinks about learning and studying and practicing law. 80 years or so after the address by Langdell that I just quoted from, and a quarter century after the rise of legal realism, roughly a quarter century after the rise of legal realism, this is not an American scholar you would know or I would expect you to know. His name is Daniel Boorstin. He was a professor at the University of Chicago in social and legal history, later became what we call the Librarian of Congress, which is a sort of a significant non-political post in the United States Congress in charge of its vast collection of books and manuscripts. But he wrote a law review article in 1946, 47, in which he looks back at the progress of the teaching and study of law since Langdell's time, looks back a bit wistfully, I would say, by the way, and he has this in part to say. The lawyer, it is argued, has to be a social scientist, simply because otherwise he will be a bad lawyer. His predictions will be faulty unless he can calculate the probable effect both of large social forces and of intimate, non-rational influences on the decision in any particular case. Now, as I say wistful, he's sort of bemoaning the move of the perception, at least of American lawyers and the legal academy, move to a perception that law is but social science applied in a particular discipline. But Boorstin, in a sense, was fighting a losing battle. Today, although we don't articulate it, we don't think of it this way, almost all of us come to the study of law with the mindset of the social sciences. And we have left behind, to a very large degree, the quite different mindset and approach to the world of the scholar in the humanities. And I want to address, as the primary thrust of today's talk, just exactly how the fundamental methodologies of the social sciences differ from those of the humanities. So legal realism, which I think you've already considered here, true? You've covered legal realism? Legal realism, at least in the States, has to be understood in fair measure as a response to Langdell and the changes he makes, to his form of positivism. The legal realists say, no, you're much too formal. Your idea of judges as formalist creatures is just not in tune with reality, and you need to think more realistically about what influences judicial decision-making, what influences legislative decision-making, and that, and that's, legal realism is in a sense, a real sense, a response to Langdell's sort of formalist positivism, okay? And from legal realism, you have the law and society movement emerge much closer to our day, in the 60s, 70s, 1980s. And some of the leading thinkers in the law and society movement, one of them's close to home to me, a professor, a legal historian named J. Willard Hurst at the University of Wisconsin in my home city, is heavily identified with being an early advocate of the law and society movement. A man who's still living, Lawrence Friedman at Stanford University, is closely associated with the law and society movement. But in any event, in general, that movement, law and society, which is itself an outgrowth of legal realism, argues that law professors, law students, and lawyers must really get out in the field. We ought to go out into the world, consider it our scientific field study, gather data from clients, learn about their broad life experiences, the history of their corporations or their business enterprises, whatever it might be, and that legal institutions are part of this field study. Police departments, courts themselves, the judicial system, prison bureaucracies, legislatures, all of these legal institutions are out there available for study by lawyers and law students and law professors, and that this is then how we learn how people and institutions interact in real life, how the law actually works and affects people and the institutions that administer it. So to the law and society movement, law simply is a part of social life. It's in a sense inseparable from life itself. And from the perspective of the law and society's movement, law and society movements, lawyers are effective advisors to people and institutions to the extent and only to the extent that they have immersed themselves in gathering data from and understanding these same people and institutions. So what you have as you run from Langdell to legal realism and then expansion of that into the law and society movement, what you have certainly is differences in how engaged with the broader world the legal academy is, or these thinkers are, and expect you and I to be. But all of these, legal realism and the law and society movement, they all share the unspoken assumption again that fundamentally we're all engaged in a social science as lawyers. And there's important advances. I mean, legal realism was still sort of worried about predicting case outcomes. And just, the critique of Langdell's positivism is you're not looking broadly enough at the factors that affect case outcomes, but still the focus is on predicting case outcomes. Law and society at least expands the field of vision beyond case outcomes to look at how do people, how do companies, business enterprises, courts, bureaucracies, how do they actually experience and apply law, rather than worrying about one particular, case outcome, Jarndyce versus Jarndyce, or whatever it may be. So law and society movement is, to my mind, at least a great advance in the study and understanding of law. And it allows us to begin to see the interconnectedness of legal problems for people and institutions. But again, the unstated assumption, the unexamined assumption, is that we're engaged almost entirely in a social scientific project. That's what I want to ask you to examine just a little bit with me for the rest of today. And you might say, well, look, Strang, it was fine to watch you in Making a Murderer, but why now are you so worried about locating where and how we think about studying law? Why are you worried about this distinction that you're positing between the social sciences and the humanities? Well, because I'm a lawyer who cares a whole lot about what law will look like and how it will affect people, the societies in which you and I live, how you as lawyers will shape to some extent or help to shape that society, how we will serve the people who are our clients, the people we encounter, and the people who, in a sense, have authorized the status we have as lawyers. Lawyers who maybe go on to become judges and whatnot. So that's a part of it. But beyond that, I think that locating law as a discipline really may fundamentally inform how we think about law, how we study law, and how we practice it. All right? And I'm going to suggest and explain very shortly that the basic methodological orientation of any social scientist is very different than the basic methodological orientation of the artist, of the writer, of the poet, the philosopher, the historian, or any humanities scholar. Each one of these orientations or basic methodologies is valuable. They're enormously valuable in and of themselves and as applied to law in an interdisciplinary way. They're all valuable. Don't get me wrong for a moment on that. But they are different. And they can produce not just different insights, but fundamentally different ways of thinking about the world and about people and other creatures in the world. So this is all, in a sense, what I'm asking you to do is all, in a sense, before law and society. It's what are we doing at all, and what are the methodologies by which we do it? By asking ourselves about the fundamentals of our project in law school and in living as lawyers. Are we engaged with the world as social scientists or as students of the humanities in the end? And I think, you know, if we grapple with that question, we then are in a better position to say, how will we practice and think about law? And will we be ready for and agents of what law can do to help improve people's lives? All right. I tend to fall behind on my slides. You just have to live with that, okay? But law and society, I'm giving you just a little bit of sort of review of that. Friedman, whom I mentioned at Stanford, does a nice job in a 1986 article of simply saying, law and society explains or describes legal phenomena in social terms. I mean, that's as good a condensed description of that movement as any. And I've got this slide in here because what I'm going to suggest to you, and I'll spend a good deal of time on this in my third and my final lecture, is that I think where law and society is and should take us next is still broader to something you might think of as systemic justice or systemic injustice, perhaps. I think that's the next important expansion of scope and sophistication in thinking about the role of law in the world. And just by way of brief introduction now, by systemic injustice or systemic justice, what I mean, and what a loose collection of scholars working in this area in a whole variety of fields, by the way, not just in law schools, in fact, primarily not at law schools. But what I mean by that, and in general what these scholars mean, is that social systems produce predictable advantages and disadvantages to different groups of people. You know, large groups of people predictably will be advantaged by social systems. Others will be predictably disadvantaged by social systems, whatever those might be, and we'll plow into that a bit in lecture 3. That these systems themselves are interconnected. That is, that, say, a child welfare bureaucracy has important connections to an adult court system, which then has important connections to, public benefits, for example. That these systems tend to overlap and get connected to each other in important ways. If you have a conviction over in court for a certain time of crime, you now may be prohibited from receiving certain public benefits. All right? That's the kind of systemic connection that I'm describing for purposes today. Many, many people argue, the systemic injustice folks, many people experience these overlapping social systems as almost continuously unjust. They are simply over and over disadvantaged by them. Often the disadvantaged groups are women, the poor, people from ethnic minorities, you know, but not always. I mean, there's, depending on the system we're talking about, there are different groups who will see predictable disadvantages, but many, many people, probably most people, experience these systems as regular causes of injustice. And that if we as lawyers and as other concerned citizens are to mount effective responses to systemic injustice, we too must think systemically. For law students, what that means practically, according to the systemic justice folks, is we have to get out of our silos of thinking, you know, I'm a corporations lawyer, or I'm a public benefits lawyer, or I'm an immigration lawyer. Even in law school, we have to get out of, well, this is my torts class, so we don't talk about contracts here. Or this is my real property class, so we don't talk about taxation. All right, that the real world to the systemic justice folks does not recognize or understand or apply these same silos or neat, you know, fenced off disciplinary areas. And that when you really get out, you know, the single mom who's got 3 kids in school and is trying to navigate her way through school suspension proceedings and maintaining public benefits and, you know, getting housing, keeping a job, dealing with an eviction proceeding, you know, that real people experience life in a way that has nothing to do with how we're taught law, with neat little boxes or silos, criminal law over here, you know, taxation over here. All right? So that's, I think, what I'm hoping you all will, 20 years from now, be conversant in discussing systemic injustice, and that it will be the natural outgrowth of the law and society movement. But for now, for today, I want to start before law and society. Systemic injustice is beyond law and society, and we're still at the before. All right. So, basic fundamental methodologies. And, you know, before you start throwing things at me, yes, I understand that I'm speaking very generally here. You know, I understand if you have a background in psychology, or if you have a background in political science, or whatever it might be, you can quarrel certainly at the edges or at the specifics with a lot of what I'm about to say. I'm simply trying to give suggest to you a basic fundamental methodology that's common to the social sciences and then to the humanities. I want to suggest to you that what the social sciences share is that they are objective in a particular way. I'm using that term in an idiosyncratic way. They are objective in this sense. They treat the human being in a sense as an object. I don't mean that in a derogatory way, but they are treating the human being as a black box or an object that can be observed externally. All right, so by objective, what I mean is sort of an outside-in approach to human beings. Here's the human being, there she sits. If we as a social scientist stand here, we can observe what she does. We can observe what she does in response to certain stimuli. If we apply heat, if we apply loud noise, she will react in a certain way. And we can measure that. We can quantify it. We can gather data. We can compare this human being's response to this human being's response to see what the similarities or dissimilarities are, either by degree or by kind. So it's in that sense that I'm speaking of human being as object, and the study being from the outside in. The social sciences tend to be empirical. They rely on data gathering, analysis of data, and then drawing, if we can, conclusions or tentative conclusions from data. They are quantitative, as I mentioned before, as on the whole. Okay, again, on the whole. And mostly, and perhaps contestably or arguably for some of you, mostly, at least at the fundamental level, the social sciences stand apart from moral values. That is, they don't come a priori with a moral value about something or assigning good or evil to something. They are engaged in observation, measurement, experimentation, reporting, and then refinement of experimentation, okay? Broadly speaking. So the moral and the aesthetic are not questions with which the social scientist typically starts. Let me give you an example, a concrete example. Let's suppose that the state of Hawaii, which it in fact did, but let's suppose the state of Hawaii adopted an unusually strong gun control statute, quite a bit more rigorous in the controls placed on private ownership of firearms than in most of the 49 other states in the United States. So let's suppose the state of Hawaii did that. The social scientists then would be very interested in saying, okay, so what were the results of that statutory change? Did the number of crimes per capita with a gun rise or drop? What were the attitudes that people had over time about the new legal regimen? What happened to gun ownership? Did people surrender guns or did they hoard them to the extent they were lawful owners because of this new statutory change? All of that would be the purview of the social scientist, all right? What would be outside that purview would be saying that Hawaii should or shouldn't have adopted that new statute, that gun control is good or it's bad. I mean, that's not where the social scientist starts. She asks, or he asks, the policymaker, who he sees as someone separate, he asks the policymaker, what are you going to do? Or, what would be helpful from me in making your decision on policy? And I'm agnostic as to what policy you develop. You tell me what policy it's going to be or what I can do to help, and we'll go from there. All right? That's the sense in which I'm suggesting to you that the social sciences start apart from moral or aesthetic values. All right? With me so far? Okay. So, then if you think about the different disciplines within social science, they work to different degrees within this basic methodology or framework. Some are interested in large-scale studies, some in small or individual scale study. Behavioral psychologists might be interested in one person's response to certain stimuli. Econometricians might be interested in an entire nation's collective response to a particular stimulus of a legislative change, for example, new statute, new social policy of some kind. But they all, I think, start from this basic methodological place. All right, the humanities. Here I'm going to suggest that the humanities, in comparison, are subjective in, again, a special sense. The humanities treat, I think, the human being as subject, as the whole reason for the undertaking, rather than object. And the humanities, whether it's the fine arts, it's music, philosophy, whatever it might be, what binds them together, I think, at a basic level, is that they tend to try to understand human behavior and human experience by exploring from the inside out. By starting with, what does it mean to be human? What is humanity? What is it at its best? What is it at its worst? What makes us worst? What makes us best? What can we learn about the universal of human experience by studying one person, by burrowing into the head of one fictional heroine in a novel? What do we learn about all of humanity by exploring one person's experience, or by trying to evoke a particular experience in a human being by the brushstrokes that we've used on canvas, by the notes that we've scored on paper, by the novel, by the poem? It is an internal exploration out. It's concerned, the humanities, all of them are concerned very much with the intangible as well as the tangible. Concerned with emotion, irrational responses. Not just what are the responses, but how do we, and when and why do we react irrationally? Why do we engage in self-defeating behavior? Why do we behave nobly and ignobly? So let me try to give you just one simple, tangible example of this. How many of you have read, or at least know roughly about Hannah Arendt's work, Eichmann in Jerusalem? 1963 book. Hannah Arendt was a political thinker, a journalist, someone I think very much in a humanities tradition. And after Adolf Eichmann, who'd been a leading member of the Third Reich, was apprehended in South America and brought to Israel for trial, she attended the trial in the early 1960s. And she simply sat in the courtroom and watched. And the entire book, the subtitle of which is a report on the banality of evil. The entire book, it's not terribly long, but the whole thing is a meditation on how an evil like Nazism, like the Third Reich, grew, how it came to be, when it depended on individual human beings, like at that point the very much disempowered Adolf Eichmann, who's in the dock, who's in custody, who's on trial for his life, and looks like a beaten, tired old man in court. And it's simply Arendt exploring really large, significant questions about human experience through listening to and watching, literally watching, one man on trial and hearing testimony about what he did, what his role was in the Nazi regime, the day-to-day stuff of his life during 1939 to 1945. Okay? And she was struck by how banal all of it was, how regular and bureaucratic this enormous evil was in its actual application. Ordinary record keeping, careful segregation of property stolen from internees, values assigned to it, efforts made so that it wouldn't be pilfered by other bureaucrats, on and on, whatever it was. Making trains run on time, staffing courts, all to work this enormous evil as a regime. And, so what Arendt was doing in that book, which you've got to read at some point in your life, by the way. I mean, it's an extraordinary meditation, as I say, on this. What she's doing is she's coming to an insight about evil, about as large a topic as you could possibly imagine. She's coming to an insight about evil that's powerful and universal. That it's not, evil doesn't present itself as a horror movie to us. The difficulty, the real problem with evil is it presents itself to us with governmental regularity, with mind-numbing repetition and small acts of people who are simply playing a role in some large hierarchy. And it is in fact banal looking. And that's why it succeeds so often. That's why we don't rise up and resist, because it looks so ordinary in its manifestations. Classic kind of humanities approach, okay? An exploration from the inside out. The humanities, as a rule, are qualitative, where the social sciences are quantitative. The humanities are very much engaged in the qualities of a human experience, the qualities of art or music or whatever it might be. Comfortable with qualitative measures. This is better than that. Why? Because it is. Not because 4 is greater than 3. Or not because 17 amperes is greater than 12 amperes, okay? Qualitative sort of assessment. And the humanities tend to be interested in, tied to, moral and aesthetic values as a matter of first order. They are anything but agnostic about value in the intangible sense. It's the beginning point in general for the humanities. So with that basic, at least my suggestion of the differences in the basic methodological frameworks for the social sciences and the humanities, we can say, okay, as law students, what social sciences do we most typically encounter? Well, you've already bumped into microeconomics. You've studied the law and economics movement. And I would say since the 70s, microeconomic theory as applied to law has been the preeminent social science in law schools, in the legal academy. Had an enormous influence on faculties and the way law is taught. But political science has a frequent place, or frequent intersections with the study of law. And psychology, both behavioral psychology and cognitive psychology, very much has found its place in law school curricula and on law school faculties. We'll look next week at behavioral law and economics, which is an offshoot of law and economics. I don't think you've touched on BLE or behavioral law and economics, have you? Well, I'll sort of sketch that in the next lecture as we run through law and several of the social sciences. And as I intimated half an hour ago, the mind sciences are the sciences or blended social and natural sciences that are very much coming as important contributors to the study and understanding and practice of law. The mind sciences are where your kids, or what your kids will study when they go to law school, even if you don't. And you may, because the mind sciences are making real inroads into law school faculty and curricula already. And for the humanities, what do you encounter most often? Well, you may not realize you're encountering them at all, and you may not much in law school because of Langdell and the last 100 years of legal realism and law and society. But legal history, the intersection of law and history, is probably the area of the humanities still most commonly found in law school curricula, all right? Law and literature is a school, a movement that never quite got the attention that law and economics got, but that arose in the same decades, the 70s, 80s, into the 90s. And we are going to look a little bit at law and literature in the third week. Philosophy? Well, yes, that's still very much a part of most law school curricula, even though you don't think of it that way. But you're in a jurisprudence class right now. Jurisprudence is the philosophy of law, right? We don't think of it so much that way anymore, but you are right now you are at an intersection of law and the humanities because you are engaged in a class with Dean Kilcommons that explores jurisprudence, explores the philosophical forces and schools of thought that shape the study of law. So, those are, the social sciences we meet as law students, the humanities that we meet or should meet as law students, and why does this all freaking matter, all right? Why do these conceptual differences in methodology matter at all? Because, to my mind, after 100 years of thinking unconsciously of law as a social science and going through law school curricula that focus heavily on the social sciences as the primary interdisciplinary contributors to the study of law, we all have, me, you, we've got, by the time we get out of law school, pretty developed ideas, a fairly sophisticated vocabulary within the social sciences. We're pretty good at considering efficiency in economic sense. Rational actors, we know what that means. Least cost avoiders, you bump into that in torts. Cost-benefit analyses. Default positions, primacy, recency, nudges, free rider problems, models, how to look at a model as being helpful or not helpful in predicting human behavior or predicting results of something. Cognitive biases. You've bumped into that by the time you get out of law school. And these are all really wonderful tools for studying and understanding law, and then for going out and practicing it. They equip us, importantly, as lawyers. It's all great. But you know what many law students, at least in the States, don't have by the time they get out of law school as 24 or 25-year-olds or older? They don't have much in the way of sophistication or vocabulary to discuss justice or to discuss fairness, to discuss right and wrong. They're still doing that at, in my experience in teaching American law students at least, they're still doing that at the level they would have done it as 8-year-olds. What's fair and not fair? What's just and unjust? We just don't leave law students with much of a vocabulary or sophistication in addressing what some might think is a core reason for law being, which is to administer justice, to improve justice. And we certainly leave law school often without tools of rhetoric in persuasion, without a sense of the importance of empathy, without ways in which to imagine how legal proceedings might look different if structural or systemic changes were made. Many of us leave law school, I'm afraid, without any sense of the dignity and majestic possibility of law, of what role law can play in uplifting people or in beating them down, in oppressing them. And to the extent we have rough senses of that, we haven't as law students, because we've been starved of the humanities in law school, we haven't a sense of how to talk about that persuasively and how to think differently as lawyers about making systemic change. How to think about empathetically, to think empathetically about people who are affected by law and legal institutions. So that's why I want to encourage you to think about the difference in the methodologies, the difference in the fundamental approach of the social sciences and the humanities. Not to reject one or the other. Don't. All of these interdisciplinary approaches are enormously valuable and important. I'm not talking about rejecting or picking one over the other. I'm talking about making space for a fuller range of interdisciplinary thought, and about recognizing the ways in which law can and should be tied as well to the humanities as to the social sciences. All right. Very few of you have left, which is a great credit to you. And I want to spend another 10 or 15 minutes by dropping back historically and considering a juncture or a junction point at which you might say the sciences and the social sciences made their entry into the thinking about law in English-speaking countries and began the dominance that they would establish after Langdell. And for me, that junction point is this guy, is Jeremy Bentham. You've run into Bentham? No? Oh, no? Nobody's run into Bentham before? This is a really interesting man. This is a fascinating man, okay? Admitted to Cambridge at age 12. Queen's College, I think, in Cambridge at age 12. Into Lincoln's Inn, studying law by age 15. All right? A polymath, interested in absolutely everything all his life, the sciences especially. He lives 1748 to 1832, spends most of his life as a professor of law and philosophy at the University College of London. He is not widely famed during his day. He's viewed as a little bit as the classic sort of pointy-headed intellectual, ivory tower nut. He makes no money during his life. You know, the riches of a Blackstone don't come to him. The fame like that doesn't come to him during his lifetime. But, you know, what he does is leave us a legacy of work that touches on political and moral philosophy in law. The fragment on government certainly does that. He's equally at home in the humanities and the social sciences. As a matter of the humanities within architecture, he is the man who describes in his concept of the panopticon, which was his architectural design for a prison, describes the design of every prison in the world in 2018. He comes up with this. The panopticon, the idea is that from a central pod or hub, the jailer can observe all of the different cells, all of the wings of the prison. It is the design of every modern prison in the world, is traceable to Bentham. He gives us a wonderful work on public education, critiquing what's wrong with public education in a book called Chrestomathia. And indeed, it's Bentham who is the model for Mr. Gradgrind in Charles Dickens's Hard Times, which is a pretty savage critique, actually, of Bentham and some of his ideas. But Bentham is a phenomenal, remarkable figure in his day in diagnosing what was wrong with education in England as he knew it, and especially in education being limited to those in the privileged upper classes and not extended to the great mass of kids who were left illiterate. He writes a groundbreaking treatise on evidence that, at least in the United States, you would say is the origin of much of modern thinking about rules of evidence, the admissibility of evidence in court. He, for the first time, seeks to impose a rational system of assessing what evidence ought to be admissible and what evidence not admissible, rather than simply arcane common law rules that have reasons and roots beyond anybody's understanding or memory. He says, how can we make evidence and the study of evidence rational? How can we think about admitting that which helps prove a point, which is probative of something, and excluding that which does not help to prove a point, which is not logically probative of something? This is Bentham at its roots. So he really is a remarkable synthesis of the natural and social sciences and the humanities. He describes in his Introduction to the Principles of Morals and Legislation, legislation itself as a science. He sees rationality and scientific approach as being essential to intelligent legislation. Now, he is a bit of an oddball. This I've run through you already, but it's there for you. And I say he's a bit of an oddball, and this is not a great photo. But this is a modern photo taken in University College of London. That says Jeremy Bentham up at the top. And what you're looking at is his embalmed body. Okay? Although with a wax head. They used to have the real head, and then the head fell off, and they put it between his feet. But then graduating seniors at the University of College of London began, as a prank, to take the head out of the case and kick it around on the football field, and that didn't do the head any good after, 100+ years after his death. So they replaced it with a wax head. But good old Jeremy Bentham, in his will, after a lifetime at the University of College of London, directed that his body would be displayed in perpetuity in a case of his design, which he called the auto icon. That's, you're looking at the auto icon. And that it would be wheeled in to the Board of Trustees meeting at all future meetings of the Board of Trustees of the University of College of London, and that he would be recorded in the minutes as present but not voting. So, I mean, he is a bit of a character. In any event, his major contribution, his big idea, if you will, is the principle of utility. He is, for our purposes, remembered as the father of utilitarianism. And the idea is, the principle of utility is, that all legislation, all law, ought to be sustained, be kept, be implemented to the extent that it produces collectively more pleasure than pain, more happiness than misery, more good than evil. He simply measures the propriety of a piece of legislation or a court decision by whether it will, on balance, produce more good than evil. Does it have utility in that sense? And he's, as you'll see, he's speaking to us, these are all his terms, but he's speaking to us as a natural scientist, pleasure versus pain. He's speaking to us as a social scientist, happiness versus misery. He's speaking to us as someone from the humanities tradition, good versus evil. He's comfortable across the range of any of these disciplines, and indeed he speaks naturally in this way. He views his entire work as moral science, his term, moral science. And, his utilitarianism is at least an organized philosophical viewpoint. It's consequentialist, to be sure. Kant would hate it, all right? It's relativist, it's consequentialist. Good is measured simply by whether more people benefit than people seeing detriment from a given piece of legislation, for example. But it's an organized philosophical point of view. He was a tremendous critic of English law as it existed during his lifetime, across a stunningly broad range of concerns. Anybody here interested in animal rights? Nobody? Nobody interested in animal rights? That's sort of something that's current today to be thinking about among lawyers and law students. What rights have non-humans? What do we owe animals? What standing ought they have under the law? That's Bentham. Bentham wrote on that. Bentham urged laws that would assure the humane treatment of animals. Nobody was doing that in the 18th century or early 19th century. Nobody. Bentham's out 150 years ahead of everybody in writing and teaching about the obligation of humans to assure the humane treatment of other animals. Okay? He's a radical and a reformer. And he's trying, he's challenging the English establishment of the day to say this can't all be about landowners and about the gentry. The point of utilitarianism was we have to look at all the people. How's everybody doing? Are we producing social benefits for the largest possible number of people, even if that produces pain for the wealthy few? One of the ironies and tragedies, I think, of his life as a radical and a reformer is that he dies in 1832, which is the very year that finally Parliament passes the Great Reform Act to do something about expanding voting rights. Until 1832, you had to have a vast amount of land, be the owner of a vast amount of land, or you had no right to vote in England. Bentham said that's wrong. If you're a male, if you're a male human being, you ought to be able to vote simply because you're a citizen. He wasn't quite on to the whole woman thing yet. Step at a time, right? But he argued that the ballot ought to be open regardless of land ownership. The tenant ought to have a vote equal to the landlord. Parliament didn't quite get there in 1832, but it did reduce substantially the size of the landowning requirement to be an elector, to be a voter. It reduced considerably the fee you had to pay to stand for office, so that an ordinary person might be able to pay the fee to stand for election to the House of Commons. And it did something, at least, to address the huge problem of what were called rotten boroughs in England at the time, where because the right to vote was determined by this, by sizable land holding, you had entire legislative districts in the House of Commons where there was 1 or 2 or 3 people eligible to vote. It's called a rotten borough. Effectively, a very wealthy man could assure himself a seat in the House of Commons because he or members of his family were the only and a small handful of voters in the entire borough. And by expanding the franchise, to smaller landowners, you increased the number of people eligible to vote within a borough, and it made an advance in democracy. All of that comes to pass as Bentham is dying, as this radical and reformer is dying. But what he does do is propel the law, I think bend its direction in the direction of thinking as social scientists, thinking rationally, having an organizing principle by which the efficacy, the desirability of legislation or a court decision could be measured. Utilitarianism. Utilitarianism, by the way, is something you're familiar with if you looked at law and economics. The microeconomist has a very difficult time getting himself away from utilitarian philosophy. They're uncomfortable about it because microeconomists tend not to like the idea that disadvantaging you is fine as long as the advantage goes to 2 people as long as two people see an advantage, then, harming you is acceptable because the benefit goes to two. Economists have a hard time with that idea, but they live in the shadow of the utilitarian, of Bentham or Adam Smith, and have a hard time, I think, conceptually getting out from beyond that shadow in some ways. So I just wanted to give you an introduction. I didn't expect that it would be new to you, to somebody who I think is a transitional figure in the development of the way we study and think about law, and locates us initially in the importance of an interdisciplinary approach, whether with the social sciences or the humanities. So next week, I'm going to look more closely at the social sciences we encounter most often in law school. Again, microeconomics, political science, behavioral psychology, and then how we encounter them. And I'm going to argue to you that the social sciences you meet as law students often are flattened and distorted in law school in ways that would make them not terribly recognizable to the psychologist or to the economist, at least that would look distorted and flattened from the perspective of people actually in those fields. But we'll look at those intersections with law next time we get together. Questions?
In American law schools, do they, like when we leave here, a lot of us will go to either Blackhole Place or King's Inns to be solicitors or barristers, and there's a professional teaching you how to speak in court or how to talk to your client. So did they do that in American law schools?
They don't.
So where do they do that?
We don't separate solicitors from barristers. The role is simply united in the concept of attorney at law or lawyer, whatever term. Americans tend to use the term attorney, and I tend not to like that term. I prefer the term lawyer, but there is no separation of barrister and lawyer, and we don't have the experience of keeping term at King's Inn or articling, as Canadian law students do, some sort of formal internship after law school. Most law students, most American law students, having gotten an undergraduate degree, having then done 3 years of law school and getting what's called a Juris Doctor, a JD, then will simply go out into practice. A very few of the top students will become law clerks, and then there's a whole hierarchy of law clerkships. Probably state court law clerkships at the bottom, and the state Supreme Court, federal district court, which is the trial level federal court, Federal Court of Appeals, and then a very few, 36 law students in the country a year get a clerkship at the United States Supreme Court. So there's very much a hierarchy in law clerkships, but you've got to be top 5% to get a clerkship at all, probably, or top 10% certainly to get a clerkship. But that's, the American system really is different than the other English-speaking countries that way. Australia is starting to look more like America, by the way. They're erasing the distinction between solicitor and barrister in some states in Australia. I think the Northern Territory has, Victoria may have, but no, the differences are noticeable. Any other on anything?
Just on the panopticon, I don't know if I read this or not, but I read that initially all the prisoners were, they had kind of a hood over their head.
Mm-hmm.
Was that Jeremy Bentham, or did somebody do that after him? Was that his idea? Because they all went basically mad.
I think Bentham imagined that, spoke of that, and the idea was that the point of being in prison was penitence. And that's what that prison is a great evil. And Bentham argued that prisons are a great evil. If they're to be justified at all, they have to produce a greater good than the evil they do of locking people up, depriving them of their freedom, breaking up families. And the greater good that they could do was by promoting penitence and self-reform, self-rehabilitation among the inmates of prisons. And I think his idea was that it, being hooded at least part of the time was good for introspection and reflection on one's wrongs. Now, nice idea. I personally have never been penitent in my life for more than about 20 minutes of sustained thought, sustained feeling bad. So I don't know that we can expect anybody to be penitent for 5 years or 10 years or 20 years or whatever, prison sentences often turn out to be. But that was his idea of the possible justifying good to be produced that would offset the evil of prison and therefore justify the existence of the prison. You done? Good. I'll see you next week.